Hello and welcome. This will be a 2 to 3 part series. This is part 1, and it will be with regard to the Commonwealth's motion to exclude defense witness Richard Green's debunked quote opinions. And I will also be going over Richard Green's affidavit and the defense's motion. So again, this is part 1. If you've already read this motion from the Commonwealth, feel free to disregard this video, but I'm doing it like this so that we have a chronological arrangement here, with the Commonwealth starting unnecessary fights with the defense to exclude witnesses unnecessarily. I just want to point out first of all, guys, this is an oddly worded motion. To me, this is the prosecution's attempt to sensationalize the drama in this case. Seldom is the word debunked put into the title of a motion. Generally, the title of a motion is supposed to be simple, short wording. It's a motion. It's a motion to exclude. What I'm saying is it would have been sufficient for the prosecution, the Commonwealth, to write Commonwealth's motion to exclude defense witness Richard Green. That would have been sufficient. But it's clear that Hank Brennan is still playing dirty, and he felt the need to title it debunked quote opinions end quote. So peculiar, so outlandish even, guys. Just Hank Brennan, I don't know, Michael Morrissey must be paying him really well. I was thinking about this the other day, like, Hank Brennan, what are you gonna do when the case is all over and you've got all these people hating on you for being a troll and for not having your facts straight, dude? Hank Brennan, what are you going to do? How are you going to show yourself in public? Being the troll that you are, the liar that you are. Anyway, let's start with the motion. It reads, the Commonwealth respectfully moves this honorable court to exclude the proposed expert testimony of Richard Green relative to 2 issues. 1, the claim that Jennifer McCabe's phone Googled, quote, how long T die in CIKD, end quote, or, quote, how long to die in cold, end quote, at any time prior to 6:23 a.m. on January 29, 2022, and 2, that Jennifer McCabe's phone incurred user deletions of any data related to Google searches. So already you see the prosecution's agenda. They want to exclude any searches made before 6:23 a.m. Okay, continuing. Exclusion is appropriate because both claims lack any evidentiary support and the claims cannot be made in good faith. Allowing introduction of baseless claims without any scientific, forensic, or factual support would be misleading to the jury and disruptive to the interests of justice. Pulling away from the motion, guys, is probably going to be a very long part 1 because of this damn motion. I just want to say, Hank Brennan's full of shit. Let's reread that paragraph. Allowing introduction of baseless claims without any scientific, forensic, or factual support would be misleading. Hank Brennan, it would be misleading, like you were not misleading with your questions to Dr. Russell during the unnecessary Daubert hearing, Hank Brennan, how you omitted details of arguments, right? You omitted details from the entire picture, the big picture that is the truth, to corner Dr. Russell and get her in a gotcha moment over and over again. Misleading, Hank Brennan. And guys, remember Ian Whiffin's testimony. Ian Whiffen did not hash verify those cell phone extractions. Ian Whiffen testified on behalf of the prosecution, and Ian Whiffen owns ArtX. Ian Whiffen appeared to be a credible witness there, but he admitted on the stand that he did not hash verify the cell phone extractions, rendering the cell phone extractions and his own testimony useless. In metadata forensics, all the metadata has to be verified in one way or another, generally through hash values. And again, Ian Whiffen admitted that he did not hash verify the metadata. So what was the point of Ian Whiffen sitting on the stand and testifying as a so-called expert when he did not even verify the validity of the metadata? So what I am saying is that Ian Whiffen's entire testimony, in which he discussed those Hoslong to die searches, Ian Whiffen's entire testimony was misleading. Hank Brennan has zero room to talk about anybody being misleading. Richard Green was the only one. Richard Green was the only metadata forensic expert to hash verify the cell phone extractions. That's why we all know, guys. That's why we all know that Jennifer McCabe made that search, Hoslong to die in the cold, at 2:27 a.m. Continuing with the motion, the Commonwealth's expert Ian Whiffen is Celebrite's senior digital intelligence expert and an expert in digital forensics. He has engaged in a comprehensive analysis of the two above claims lodged by Mr. Green. No, he hasn't. No, he hasn't. Again, guys, Ian Whiffen wasted everybody's time. You could have grabbed anybody off the street who knew a little bit about cell phone extraction data, and they would have had about the same amount of credibility, which is zero. Okay, Ian Whiffen wasted everybody's time because the so-called evidence he was referencing, the metadata evidence, was not hash verified. Look at Hank Brennan. Look at the prosecution presenting Ian Whiffen as if he's a credible expert. And in my opinion, he's not. I made a video about Ian Whiffen, and I said, you know, if I were called upon to testify as a data forensic expert, I would say I need to have the hash verified data. I don't have the hash verified data, so I'm not going to testify on the stand. Ian Whiffen exposed himself as an incredible, a person, a so-called expert who lacks credibility and who lacks integrity. How are you going to testify on the stand as an expert without verifying that the information you're testifying about is verified, is hash verified? I'm saying, like, I don't give a damn about Ian Whiffen. I hope he never gets to talk again in this case. You know, zero integrity as someone who is in the cell phone extraction industry. Like, okay, all right, I'm continuing. There's a footnote here. I will be reading it. So right here in the first sentence, the Commonwealth expert Ian Whiffen is Celebrite's senior. There's a number 1 after the word Celebrite. So we're going to read the footnote. Number 1, it reads, Celebrite is the leading forensic data extraction software tool that provides forensic examiners the ability to access and analyze data stored within a digital device. The Celebrite software allows an examiner to parse layers of data through different methods of extraction and analysis. And guys, pulling away, though that may be true, again, the data doesn't mean a damn thing if it's not hash verified. Continuing with the motion. His analysis has included the implementation of forensic data science, personally reviewing the device data, properly and accurately employing Celebrite technology, and a study of materials generated from the device. And there's another footnote, number 2. We'll get to that later. Continuing, after a comprehensive study of the forensic data and consideration of Mr. Green's claims, Mr. Whiffin's opinions disproving Mr. Green's claims are unequivocal. No, they are not. They are not. Oh, the prosecution and their lies. They just won't stop, guys. They won't stop with their lies. Continuing, Mr. Whiffin provides, quote, I can state with absolute certainty that there is no evidence whatsoever on this device that the Google searches, quote, how long to die in CIKD, end quote, or, quote, how long to die in cold, end quote, occurred prior to 6:23 a.m. on the 29th of January 2022, end quote, and in parentheses, emphasis provided. Again, that statement in and of itself is a lie. It is a whole entire lie. Continuing. Moreover, Mr. Whiffin concluded that there is, quote, no evidence that the user tried to delete any search history or that tampering occurred with any of the data I examined, end quote. Sorry, that was a quote. It was, quote, no evidence that the user tried to delete any search history or that tampering occurred with any of the data I examined, end quote. Again, Ian Whiffin, why didn't you hash verify the data you so-called examined? Continuing. Consequently, Mr. Green's testimony on these two issues is wrong, factually unsupported, and should not be admitted at the jury trial in this matter. Again, Hank Brennan pulling away. Hank Brennan has zero room to talk about anybody being misleading. He needs to look in the mirror. Continuing with the motion, the underpinnings of Mr. Green's testimony on these two issues fails to meet the requirements set forth in Daubert versus Merrill Doe Farms Incorporated and Commonwealth versus Lanigan provides a case law because, one, the defendant cannot meet its burden to demonstrate that Mr. Green is qualified to testify to these two opinions. And number 2, Mr. Green's opinions do not meet the minimum requirements of digital forensics and lack any scientific basis. And 3, Mr. Green will be unable to provide any facts to support his previous testimony, which has been completely discredited relative to these two issues. Guys, this is all misleading. It is all misleading, and it's all a farce. It's a show. It's again, just like they pulled it off with Dr. Murray Russell, they pulled off getting an extra 16 hours of testimony from Dr. Russell with the unnecessary Daubert hearing Hank Brennan called upon and Judge Beverly Cannoni granted, wasting thousands of dollars of the defense team, of Karen Reed's money, right? This is yet again Hank Brennan using the same dirty method to strip Karen Reed of her financial security. Again, financial abuse. It's unnecessary. Richard Green testified as a digital forensic expert in previous trials, much like Dr. Murray Russell testified as a forensic pathologist in previous trials. Hank Brennan keeps pulling this shit, and I really wish Judge Bev would call him on it. Ooh. Okay, there was a footnote back up here. I'm going to refer to the sentence. And accurately employing Celebrite technology and a study of materials generated from the device. So that footnote is number 2. And down here it reads, Ian Whiffin report dated December 2024, attached in Exhibit 1. And generally, when I'm able to access these motions, they do not include the exhibits. I would have to go down to the courthouse to get the exhibits. Okay, continuing. Procedural history. On June 21, 2024, Mr. Green testified on behalf of the defense. Mr. Green purported to be a forensic expert specializing in computer cloud. Purported, guys. Just immediate disrespect, much like the disrespect they showed toward Dr. Murray Russell. Just completely overlook all those decades of experience and expertise, and the fact that both of these defense witnesses testified as experts in previous trials. Guys, I said it in the last video, like if the Karen Read case is an excellent case to study if you want to know how low corrupt institutions will go, namely prosecutorial procedures when it comes to corrupt lawyers, corrupt attorneys, corrupt DAs like Michael Morrissey. The Karen Read case will go down in history as an excellent exhibit of blatant corruption. Continuing. Mr. Green purported to be a forensic expert specializing in computer cloud surveillance systems and other systems. Mr. Green testified that he was asked to parse through data from photos belonging to Jennifer McCabe, Karen Read, and John O'Keefe. He said the Google search was found in a write-ahead log where data is stored temporarily before it's written into the main database. Mr. Green claimed, quote, just by the nature of it, we'll find a lot of the newest artifacts in that WAL file, W-A-L file, end quote. Mr. Green also proclaimed that the search, quote, was in a deleted state, end quote. He testified that he found, quote, a lot, end quote, of other user-deleted artifacts in McCabe's data from the morning of January 29, 2022. On April 11, 2023, Richard Green submitted an affidavit on behalf of the defendant, opining that, quote, search history information obtained from Jennifer McCabe's cell phone indicates that on January 29, 2022 at 2:27:40 seconds a.m., the phone's user entered the following search in Safari, quote, Hoslong to die in cold, end quote. And there's another footnote, number 3. On June 21, 2024, Mr. Green testified at the defendant's first trial and rendered a similar opinion, claiming that certain phone calls were, quote, user deleted, end quote. And there's another footnote, number 4. During cross-examination, Mr. Green was broad and vague about his training, experience, and a lack of digital forensic certifications. There's another footnote, number 5. Mr. Green conceded during his trial testimony that Celebrite modified their software based on his misinterpretation of data from Jennifer McCabe's cell phone. Another footnote, number 6. Despite knowledge of his error, Mr. Green has yet to submit a revised written report or opinion. Again, guys, to me, this is hogwash because, again, Richard Green was the only digital expert in this entire case who hash verified the cell phone extractions he observed and testified on behalf of as being a data expert. Ian Whiffen, despite his leadership in the industry, did not hash verify. I'm saying anybody following Ian Whiffen in the industry, anybody taking any lectures from him, they need to question him about why he did not hash verify the data he sat on the stand to testify as an expert about. Okay, it's enraging, guys. I know I'm yelling. It's enraging. The number 3 footnote reads, Affidavit of Richard Green in support of defendant's motion for order pursuant to Massar Crim 17, directed to Brian Albert, Verizon, and AT&T, attached as Exhibit 2. Footnote number 4, see June 21, 2024 trial testimony of Richard Green at page 23 to 32 as Exhibit 3. And number 5, see Exhibit 3. So all the footnotes are referencing exhibits. Okay, continuing. I'm going to read this again. Despite knowledge of his error, Mr. Green has yet to submit a revised written report or opinion. Why isn't Hank Brennan getting on Ian Whiffen's case about not hash verifying the data? Where is Ian Whiffen's revised written report or opinion? Continuing. In response to Mr. Green's misconstructions, the Commonwealth retained misconstructions, guys. The Commonwealth retained 2 experts in digital forensics, Jessica Hyde and Ian Whiffen. During the defendant's first trial, the court permitted a courtroom demonstration by Mr. Whiffen to assist the jury in understanding digital forensic and how the Google searches were stored within the digital databases, specifically the Safari internet browser. See generally Commonwealth versus Sosa provides a case law. In parentheses, when digital evidence is voluminous, parties should consider authenticating and admitting excerpts when jury may find it difficult to master the technology to find and view relevant portions of evidence. Again, the audacity. When digital evidence is voluminous, parties should consider authenticating. But Ian Whiffen did not authenticate, guys. He did not authenticate a damn thing. Continuing. Additionally, Jessica Hyde, a highly qualified forensic examiner, conducted an encompassing review of digital artifacts, file systems, and conducted independent, peer-reviewed experiments to determine that Jennifer McCabe's phone was in use at 2:27 a.m. when the Safari browser was open and looking at a website for Hockamuck Sports. At 6:23 a.m., the same Safari browser tab was engaged and a new search for how long, quote, how long, end quote, was conducted when, quote, Apple produces a suggestion for how long to digest food. The search is instead completed with how long tea die in COLD, end quote, at 6:23 a.m. A new search is conducted at 6:24 a.m. of, quote, Hoslong to die in cold, end quote. This finding was consistent with Trooper Guarino's review of the cell phone extraction and with testimony of other witnesses. Trooper Guarino, like, is the prosecution really referencing Trooper Guarino as a credible witness at this stage in the game? What the fuck? Trooper Guarino, who testified that Karen Reed's cell phone connected to John O'Keefe's Wi-Fi at 12:36 a.m., but Trooper Guarino couldn't connect the dots, and neither could Trooper Joe Paul connect the dots. Trooper Joe Paul is over there on the stand testifying that Karen Reed backed into John O'Keefe at 12:45 hours, while simultaneously Trooper Guarino is on the stand saying that Karen Reed's cell phone connected to John O'Keefe's Wi-Fi at 12:36 a.m. at One Meadows. So Karen Reed was at 34 Fairview at 12:45 a.m. while she was simultaneously at One Meadows at 12:36 a.m. Okay, guys, like, Trooper Guarino, and okay, I'm gonna keep going, guys. Okay, argument. Richard Green's debunked opinions are not an example of a, quote, battle of the experts, end quote, best left to be resolved by the fact finder, but instead an attempt to infect the jury with an inadmissible opinion that is not premised on reliable digital forensics. Bullshit. Continuing, Celebrate has updated its software to prevent manipulation of data. Shortly before the defendant's first trial, Celebrate created and introduced Physical Analyzer software version 10.2. Since the defendant's first trial, Celebrate has added another version of updated software 7.67. The updated version removed the timestamp value from records sourced from the Safari's browser state.db because, quote, further research shows that the timestamp is not a reliable source for a timestamp relating to the URL shown, end quote. The basis for Mr. Green's contested opinions has been refuted not only by the Commonwealth's independent experts, but by Celebrate itself, who has removed the type of timestamp relied on by Mr. Green from Celebrate's decoding engine. Again, this is Hank Brennan, guys. This is Hank Brennan's continuing efforts in confusing the public with false facts. Continuing. Further, when Jennifer McCabe's cell phone extraction is analyzed in the newest version of Celebrite, the 227 last visited timestamp no longer appears on the extraction report. Rather, the time shown represents the status of the browser tab and digital forensics artifacts pertaining to web history and Apple mobile Safari. Again, confirm that the, quote, "house long to die in cold," end quote, search occurred at approximately 6:24 a.m. Likewise, there was no evidence that the Google searches were user deleted. Total lie, guys. Total lie. Again, this is the prosecution relying on Ian Whiffen, who failed to hash verify the cell phone extractions before he testified about them as a so-called expert. Ian Whiffen, to me, as of today's date, has zero credibility, and so too does Hank Brennan and the rest of the prosecution fools. I'm going to read this footnote. Number 7, see Jessica Hyde Digital Forensics and Analysis Report, page 4, Exhibit 4. Continuing with the motion, even though Mr. Green's claims are wrong, the defendant herself has engaged in promoting this false narrative. False narrative. Again, guys, Hank Brennan has zero room to accuse anyone of being misleading or to accuse anyone of having false narratives. Hank Brennan, zero room, zero credibility. Continuing, in a June 2023 interview with Gretchen Valls, the defendant advanced this baseless claim. Karen Reed, quote, "First court appearance after we revealed that Jen McCabe," end quote, "Miss Little," quote, "Googled," end quote, "Mr. Yannetti," quote, "yeah," end quote, defendant, and it happened at the same time as the basketball search, which also wasn't in the report, nor was the how long to die at 6:23 that she admitted to. There was no Google activity in the Celebrite report that was handed over to us as gospel. Okay. And then in parentheses, it reads redaction with a number 8. So I will read that footnote in a bit. Guys, how is this even permissible? Like, no context? These are vague statements. Like, why? All right, continuing. Inadmissible evidence should always be excluded. Okay. I'm gonna need therapy after this case. This is toxic. Continuing, allowing debunked claims to reach the jury would necessarily risk misleading the jury and creating prejudice to the Commonwealth. Oh my God. As if the prosecution, guys, did not allow debunked claims to reach the jury. As if the prosecution wasn't misleading the jury and creating prejudice against the defense with the prosecution's planted evidence, lack of chain of custody, botched timeline that the Massachusetts State Police botched themselves, again, between Guarino and Joe Paul. They should have talked about it longer if they were going to fuck up the timeline, right? Like, oh, the prosecution has no room. Continuing, they provide a case law, Commonwealth versus Hines. Quote, the role of expert testimony is to assist jurors in interpreting evidence that lies outside their common experience, end quote. Mr. Green's factually wrong opinions would not assist jurors and would instead risk confusing jurors. it's heinous, guys. It's blasphemous how Hank Brennan leads with lies. Hank Brennan, since he has entered the prosecution, has been leading relentlessly, ruthlessly with lies. And as he leads with lies, he makes every effort to confuse the people who are following this case. And he probably intends to confuse Judge Bev too. Or he's giving her an out. He's giving her what appears to be on the surface compelling arguments. But what it really is that they are lies. Everything in this motion is a lie. It's more than playing dirty, guys. Continuing. Law. An expert witness is not permitted to testify to matters beyond an area of expertise or competence, provides the case law. The Commonwealth asserts, number 8, let me get to the footnote here. See transcript of June 20, 2023, interview of Karen Reed by Gretchen Voss. So it's another attachment. Continuing with the motion. The Commonwealth asserts that Mr. Green is not qualified to render an opinion claiming 1. Jennifer McCabe's phone Googled, quote, how long T die in CIKD, end quote, or, quote, how long to die in cold, end quote, at any time prior to 6:23 a.m. on January 29, 2022, and 2, any claim that Jennifer McCabe's phone incurred user deletions of any data. So again, this is the prosecution wanting to eliminate some strong counter arguments that the defense has in defense of Karen Reed. The prosecution attempted to completely eliminate Dr. Russell so that the knowledge about the dog bite and claw marks on John O'Keefe's arm would be eliminated from the trial. We all know that the prosecution attempted Hank Brennan especially attempted to exclude Dr. Marie Russell so that he could more effectively gaslight us about the marks on John O'Keefe's arm and continue to claim that those marks on John O'Keefe's arm came from a freaking taillight instead of what they appear to be, which is dog bite and claw marks. And with this motion, it is yet again the prosecution's attempt, Hank Brennan's attempt, to eliminate the compelling, real cell phone extractions that were verified by Richard Green so that Hank Brennan, the prosecution, can eliminate and gaslight us about the fact that Jennifer McCabe made the search how long to die in cold at 2:27 a.m. hours before Jennifer McCabe helped Karen Reed find John O'Keefe on the lawn of Brian Albert's house. You guys see the pattern here? You guys see Hank Brennan's personality, the patterns in his character, his shitty character? It's a pattern. They are the prosecution, Hank Brennan, they are trying to eliminate the strong counter arguments that the defense has, proving that Karen Reed did not do this. And to the prosecution, if they can just eliminate the 2:27 a.m. search, if they can just eliminate the dog bite and claw marks, then they have this case in their hands, right? And then the public has to erase the how long to die search at 2:27 a.m. and the dog bite and claw marks from their minds. That's what the prosecution wants to do. Like, don't believe any of this information, folks. It's all debunked. It's bullshit. Continuing. I will read this again. Number 1, Jennifer McCabe's phone Googled, quote, how long to die in CIKD, end quote, or, quote, how long to die in cold, end quote, at any time prior to 6:23 a.m. on January 29, 2022, and 2, any claim that Jennifer McCabe's phone incurred user deletions of any data. A Daubert-Lanigan hearing is necessary to assess whether the defendant may call Mr. Green to testify to these 2 debunked claims in her second trial. Not debunked, guys. And again, how dare Hank Brennan call for yet another Daubert hearing? Remember, the unnecessary Daubert hearing with Dr. Marie Russell took place over the span of 2 days, and it was over 16 hours long, 8 hours a day, 16 hours long. And Daubert hearings, as I said in my previous video, Daubert hearings are seldom an hour long. A majority of them are half hour to 45 minutes long. You guys see? And this, the defense, like, that is coming out of Karen Read's pockets. 16 hours of Dr. Marie Russell's time. And now he wants to do what? Another 16 hours with Richard Green? Hank Brennan is an abuser. That's what he's doing. He called upon Dr. Marie Russell to abuse her for 2 whole days. And now he wants to call upon Richard Green to abuse him for another 2 whole days. Right? Just, Hank Brennan is excessive. He's excessive, and he should lose his bar license, in my opinion. Continuing. He provides a case law and another case law. And continuing, it is the defendant's burden to establish that Mr. Green's testimony, quote, will assist the trier of fact to understand the evidence or to determine a fact in issue, end quote, provides the case law. And that the methodology or theory underlying the expert testimony is sufficiently reliable to be presented for the jury's consideration. Guys, or theory underlying the expert testimony is sufficiently reliable to be presented for the jury's consideration. Sufficiently reliable, guys. Do you see this? Like again, Ian Whiffen did not hash verify the information he testified about. So therefore, the testimony Ian Whiffen provided was not sufficiently reliable to be presented for the jury's consideration. Just and guys, I've referenced abusers during my analysis of the Karen Read case in previous videos. This is abusive. To take what is factually true and to rewrite the truth is gaslighting. It's an abusive tactic. And the hypocrisy is also abusive. How are you going to demand a standard from the defense that the prosecution did not even meet? Continuing, provides more case law. In parentheses, quote, proponent must establish a sufficient foundation for a judge to determine whether the expert's opinion satisfies gatekeeper reliability, end quote. Clearly, the methodology or theory underlying Mr. Green's testimony is not sufficiently reliable to be presented for the jury's consideration. A jury should not be permitted to consider baseless claims. Okay. Continuing, the defense will not be able to meet the Daubert-Lanigan standard required to proffer Mr. Green as to the 2 contested opinions, provides more case law. Conclusion. Thank God, the conclusion. For the foregoing reasons, the Commonwealth respectfully requests that the court order a Lanigan hearing or exclude Mr. Green's opinions relative to the 2 contested claims at trial. So the prosecution is saying, we want another Daubert hearing, we want another Lanigan hearing, or we want Mr. Green excluded entirely. Much like they requested for Dr. Marie Russell. Like, again, the prosecution, this is more than dirty. This is more than playing dirty. And how is it that the prosecution can claim they've got the only real experts in the industry? How can the prosecution stoop that low and say, all those expert witnesses the defense provided, they ain't qualified. They're not real experts. We are the only ones with the real experts. Like, fucking A, man. Again, it's ultimately, guys, big picture, it's yet more financial abuse from this asshole, Hank Brennan, and Adam Lally, and Laura McLaughlin. All assholes. It's dated December 31st, 2024, and it sucks. So I will begin the defense's response, including Richard Green's affidavit. Okay, guys, this is the newly submitted motion and affidavit from the defense. It was dated January 28, 2025. Today is January 30th, 2025. It reads, Affidavit of Richard Green in support of defendant's opposition to Commonwealth's motion to exclude certain testimony of defense witness Richard Green. I, Richard Green, under oath, do depose and state as follows. Number 1, the following facts and information are based on my own personal knowledge, and I could testify competently about them if called upon as an expert witness to do so. I declare that the following is true and correct to the best of my knowledge, and that I have no personal interest in the outcome of this case. Good wording. Number 2, I am the owner and president of United States Forensics, LLC, hereinafter USF, a digital investigation and data forensics company that provides services to clients nationwide. A copy of my curriculum vitae is attached hereto as, quote, Exhibit A, end quote. Number 3, I have more than 25 years of experience as a computer forensics technician and 18 years of experience conducting electronic data analyses and investigations, including analyzing computer data, cell phone data, cloud data, digital camera and DVR data, metadata media, and audio and video analysis and enhancement technology. I have conducted thousands of investigations. Wow. Okay. All right. Continuing. I have conducted thousands of investigations involving computer and cell phone forensics, data recovery, computer networking and maintenance, and audio and video enhancement. My services have been retained by numerous attorneys across the country in both civil and criminal cases, offices of the public defender, and law enforcement agencies. Number 4, I have been qualified as an expert in digital forensics in numerous state and federal courts throughout the nation, including California, Florida, Michigan, Kentucky, North Carolina, Ohio, and Massachusetts. Number 5, I obtained my associate's degree in digital forensics and computer investigations from St. Petersburg College. I am a certified computer examiner with the International Association of Computer Forensics Examiners, which is a globally recognized certification in the field of computer forensics and requires continuing education and recertification every 3 years. I also hold the following certifications: a computer-related crimes investigator certification from St. Petersburg College, a cybersecurity certification from St. Petersburg College, and a computer forensics first responder certification. And pulling away from this affidavit, it's excellent so far. I remember during the trial, Richard Green said that he has to keep up with the updates in the industry, that the information in the industry changes almost every day. So as a computer forensic expert, you have to be on top of your game. The industry information, the knowledge in the industry is updated virtually every single day. So I remember that, and it was compelling. And again, he's the only dude who had integrity. He's the only forensic expert, data forensic expert, who had the integrity to hash verify the cell phone extractions he testified about. unlike Ian Whiffen. Continuing, number 6, I am also personally licensed to operate a private investigation agency in both Florida and Michigan, in parentheses, Florida agency number, Michigan agency number, which is a requirement to operate a digital forensics company in both states. Really good. Number 7, I am presently a member of the following professional associations in the field of digital forensics: ISFCE, International Society of Computer Forensic Examiners; IACIS, the International Association of Computer Investigative Specialists; NACDL, National Association of Criminal Defense Lawyers. Okay, I was the keynote speaker on electronic data forensics at the 2008 Midwinter Conference hosted by NALI, National Association of Legal Investigators. Number 8, throughout my career, I have kept current with developments in electronic data analysis, including computer forensics and investigation training from St. Petersburg College and first responders training with Institute for Forensic Imaging. I participate in computer forensics listservs, personally research the newest development in digital and computer forensics, and attend weekly training seminars in digital forensics. Weekly training seminars, guys. That must be exhausting. Like, you gotta love this field. Like, you really gotta love computer forensics to be attending weekly training seminars. Continuing, a partial list of training events I have attended over the course of the last several years alone include, but are not limited to, holy crap, okay. 2024, training by Belkasoft, Android Forensics with Belkasoft. 2024, training by Celebrite. Unveiling Celebrite Insights. 2024, training by Hexordia Mobile Data Structures. So, guys, I am leaving the link in the description below if you want to go through this yourself. But so far, it's letter A through J for 2024 in all the training events he attended in just 2024 alone. And in as a footnote, number 1, this is not inclusive of many of the web training sources that I follow on a continual basis. Okay, and the list from 2024 continues. So I said it was letter A through J. Now it's letter K through T. It keeps going. Okay, so it 2024 ends at letter U, and then letter V begins 2023, and then it goes into double letters, double A, double B. Okay, 2023, he was busy in 2023. It continues. Oh man, triple letters now, 2022. What was that, Hank Brennan? What were you saying, Hank Brennan? You liar. Okay, continuing with the affidavit. Initial data production. Number 9. USF was initially provided with a Celebrate UFED report, in parentheses, provides a code number, prepared by Trooper Nicholas Guarino with the Massachusetts State Police, which was labeled as a, quote, full file system extraction, end quote, of an iPhone 11, provides a serial number belonging to Jennifer McCabe. In the initial report prepared by Trooper Guarino, the 2:27 a.m. search for, quote, how long to die in cold, end quote, did not appear. Recognizing that this report was not the best evidence, I personally requested the, quote, image file, end quote, for the phone in question, which I had reason to believe was produced using the Gray Key product based on the naming convention contained within the Celebrite report. Really good. And guys, Richard Green testified to some of this during the trial. Okay, continuing. Number 10. I subsequently received a USB drive containing a forensic image of the iPhone 11 provides a serial number described as, quote, J. McCabe, end quote, belonging to Jennifer McCabe, which was forensically imaged by the Massachusetts State Police using a tool known as Gray Key. The USB drive containing the forensic image was sent to USF by Assistant District Attorney Adam Lally, with the Norfolk County District Attorney's Office by way of Trooper Guarino with the Massachusetts State Police. Upon receipt, the USB containing the image of Jennifer McCabe's cell phone was assigned an internal evidence number with USF. Evidence number provides an evidence number. Notably, the USB drive containing the forensic image of Jennifer McCabe's cell phone failed to include the associated documentation containing the hash value. Thank you, Richard Green. Yes. Okay, reading that again, guys. It's so crucial. So fucking crucial. Hank Brennan, you better be paying attention, Hank Brennan. Reading it again. Upon receipt, the USB containing the image of Jennifer McCabe's cell phone was assigned an internal evidence number with USF, evidence number 22398-304. Notably, the USB drive containing the forensic image of Jennifer McCabe's cell phone failed to include the associated documentation containing the hash value, which is a well-known mechanism used to validate the data and ensure that it has not changed or otherwise been manipulated. Thank you, Richard. Thank you. All right, guys, I'm going to make a part 2. Thank you for watching.